Okay, good morning. You're here for the webinar on School is Back in Session, What Employers Should Know. Today we're going to be discussing the upcoming school year and how the scattershot reopening plans are affecting employers with employees who are parents of school-aged children. My name is John Hayes, and I'm presenting this webinar along with Allison Sues. We're both employers here at Smith Amundsen in the Labor and Employment Group. So let's get started. Some initial thoughts. Let me begin with the hard truth here that there is no silver bullet to the situation. Currently, there's no clear guidance from the Department of Labor on how employers should handle the reopening of schools, especially given that many of the schools that we're seeing, and we'll talk about this later, are going the partial online, partial in-person reopening plans. We're not sure, if anything, what Congress will do, such as maybe potentially expanding the leave benefits under the Families First Coronavirus Response Act. And there really is no one-size-fits-all answer, and each situation with each employee is going to be different. The employer's response is going to have to be on a case-by-case basis. You're going to have to examine the needs of each employee. Each employee is going to have a different and unique situation that needs to be addressed by the employer. If you look at the numbers on here, you have 42% of the companies that have already returned to work do not have a dedicated plan to address this, and only 32% of the companies planning to reopen in the near future have a childcare plan in place. So as you can see, many companies just aren't ready for this. And the last point on the slide, I can't stress enough, employers should address this problem now before the schools reopen. Do not wait until the schools reopen to deal with this. Front the issue with your employees now and start the conversation sooner rather than later. All right, here's a roadmap of what we're going to go over today. We're going to discuss the different school opening plans that we're seeing already and how this impacts employers. We'll give you a refresher or maybe even a first look into FCRA and its application to employees who are parents with school-aged children. We'll talk about some of the specific situations that may arise given the reopening plans that we're seeing. We'll discuss what to do if an employee's child happens to be exposed at school. We'll briefly cover what to do if your school employer and a teacher or staff refuses to come in. We'll also talk about some of the potential options for employers, both under FCRA and outside of it. We will look at some of the litigation related to schools reopening that we're already seeing and that we anticipate seeing. There'll be some focus on the discrimination pitfalls that employers may face given these reopening plans. And finally, we'll wrap up with some of the key takeaways for the employers. All right, school openings fall 2020. If you paid any attention to what's going on throughout the country or even locally, quite frankly, it's a mess. It's all over the place. Each district seems to be handling this differently. It truly is a patchwork of reopening plans that we're seeing. And also, I'm already seeing some districts change their initial plan based on feedback from parents. And or maybe conforming to some of the other districts that are in their geographic area. And if you look at the slide here, some larger districts such as Los Angeles and other kind of big cities are going the online only route with all schools closed completely to in-person attendance. We're seeing some that are open for complete in-person 5 days a week. This is more rare, but we're also seeing that if they are open for those 5 days, they're offering online-only instruction. What I'm seeing as the most popular plan currently is this so-called hybrid model, which combines an in-person instruction with an online component. But even with the hybrid model, we're not seeing a consensus on that. For example, I've seen some that are half day in, half day at home. Some are going for 1 week where you have a group of students in person, and the next week for another group of students in person, with that off group doing remote learning. Kind of the more popular hybrid approach that I've been seeing is this either 2 to 3 days in the school and 2 or 3 days at home, online learning. What's going to happen there is you'll have one pod of students goes 2 days in a row. You might have a cleaning day, then another pod will go on those other 2 days with remote learning happening for those remaining 3 days for the students that are not physically present in the school. It's important to note that most of these school districts, no matter which in-person route they're going, whether they're doing the hybrid or the all open, are still offering a remote-only option, and they're leaving that decision up to the parents. You can see here Milwaukee's all online, St. Louis is a hybrid, Chicago is a hybrid currently. I can say that for all of these. These are all the current plans that are in place. But you can just get and see that here in the Midwest, we're all over the place. This slide, this really is the elephant in the room. What happens when, not if, someone in school, either a student or teacher, tests positive? Be prepared for this to happen. Even the staunchest supporter of school openings is going to concede that there are going to be flare-ups of COVID this fall. And for the most part, schools are vague as to what will be done if this happens. I can guess that there will be a likely quarantine of all students, at least, very least in that classroom for 14 days. But again, it's just unclear exactly what schools are going to do when this happens. And I would imagine, even based on the plans that we're seeing, that it's going to vary by school and or district. The CDC recently issued its school reopening guidelines. It also issued a statement on the importance of opening schools in the fall for in-person instruction. As you can see, if you're looking at these bullet points here, it's very open-ended. It leaves the decision-making mostly to the school administrators and to the local public health authorities. It does encourage keeping children in those cohorts or pods, as I talked about, based on the hybrid model. And again, it also encourages the social distancing, the hand hygiene, face masks. I'm also seeing a lot of schools are mandating face mask use for both teachers and students. This is going to be a repeated theme, this last bullet point on here throughout my portion of the talk, is that we do expect the U.S. Department of Labor to issue guidelines based on these recommendations and also based on the school reopening, since, as I said, a majority of them do include some type of online component. But as of now, as of this morning, I just checked again, we're still waiting for some guidance on this from the Department of Labor. Essentially, taking together all these school reopening plans, what you're looking at is parents of school-aged children no longer can see the light at the end of the tunnel, right? They were hoping, hey, we'll get past this in the spring, we'll deal with the summer, and then kids are going back to school in the fall. That's not happening, at least not across the board. So many parents, working parents, are going to feel ill-equipped to provide appropriate supervision and assistance to their kids while also kind of juggling their paying jobs at the same time. So let's get to the meat of the presentation here. What does this mean for employers? Due to the patchwork system and choice inherent in almost all these plans, there's going to be more questions than answers at this point. We really are in unprecedented times, but employers have to be ready for this new normal of school being at least partially remote, and that many employees are just they're gonna struggle with childcare during this time. And for better or worse, employers are the ones who are being left with the decision making and tasked with figuring out how to accommodate the parents that work for them. So regardless of the number of employees that you have, businesses are expected to handle this issue. I also want to note that both the EEOC and the CDC have encouraged employers to be flexible in giving employees leave for childcare related to COVID-19. This hasn't changed with the school reopening plans. And again, this is on several of my slides. Just given all the new issues it's creating, I do anticipate the DOL to provide more guidance on this in the very near future. Some more things to think about as an employer. Proactive communication. I said this earlier, But now that you have school districts finalizing the reopening plans, employers should proactively engage with their employees. You want to anticipate what scheduling or job duty changes need to be made. And as we all know, teleworking does not work for everyone. It's not a one-size-fits-all for every business, but there may be some other adjustments that the employer or employee can make on a longer-term basis. Although, as we all know, that these reopening plans are subject to change, it's critical, so important to have these conversations now instead of when school starts. Leave policies and obligations, be aware of them, and some employees may have already exhausted their available leave, either under FCRA or not, while others may not have used any, and finally, some others may have used some. Employers need to revisit their leave policies and understand what their employees may request now that school policies are starting to get finalized and the parents are being asked to make decisions. And plus, we'll talk about this a little more when I go over the details of FCRA, but employees have until December 31st of this year to use FCRA leave. So these requests may increase. I would expect them to definitely increase. And employers should brush up on their obligations and ensure that they have processes in place to facilitate and grant these leave requests when they're made by the employees. Retention. Let's face it, with these plans reopening, and as I said, a lot of them being at least partially online, some employees may consider resigning, and you may want to retain your good employees. So employers should consider adding some benefits that could possibly support these employees. You might want to add such things as PTO banks, provide a stipend, subsidize childcare. It doesn't have to be a large financial amount, but it's a gesture that could go a long way in showing your employees that you're in this together. The mental health, it's a stressful time for all of us, right? We're all kind of trying to juggle work, and for those of us as kids, we're trying to juggle that too, and this is coming at us pretty fast. If, as an employer, you don't currently have an employee assistance program, maybe it's time to start thinking about adding that benefit for your employees. Labor turnover, this goes more to the retention point. We currently have very high unemployment rates in the country, but we may start to see some more individuals seeking jobs in the near future. You know, as of tomorrow, that additional $600 in federal unemployment benefit is ending. Currently, Congress does not seem close to passing an extension of that. So we might start seeing some more individuals in the job market. And maybe some of these people either don't have child care obligations or have already lined up some child care that will allow them to work. So you might want to think about increasing recruiting efforts to maybe get some employees who can fill the gaps for employees on leave, or those that you already have who are seeking a part-time status due to schools reopening. So the Families First Coronavirus Response Act, or FCRA, it covers all employers with less than 500 employees. Most of you on the call today are probably familiar, maybe even very familiar with this law, but I want to give a refresher given you're likely to see many requests under FCRA from your employees once the schools reopen. All right, as you know, FCRA lists several reasons to grant paid leave based on the pandemic, but today I'm only going to focus on the reason for leave being that schools or places of care are closed. The law created 2 paid leave entitlements for employees impacted by the school closings. These 2 types of leave are the emergency paid sick leave, the EPSL, and the expanded family and medical leave, the EFMLA. Together, they give the employee 12 weeks total of paid leave. It's important to note that the employee must be primarily responsible for their child's care, and that another suitable individual, such as a co-parent, co-guardian, is not available to provide the care that the child needs. Also important when considering requests for FCRA leave, and I mentioned this earlier, is that employers should account for any FCRA leave that the employee may have used when the schools were closed in the spring or for any other reason. Okay, this slide just kind of gives an overview of the two types of leave. I'll go through it relatively quickly. As I said, I think most of you are probably familiar with how the law works. The amount of pay is based on the reason for Fick or leave, and again, today we're just talking about schools closed and childcare. So for school closures, the paid sick leave provides initial 2 weeks, up to 80 hours of leave. It's payable at 2/3 of the employee's average regular rate of pay. That's up to $200 a day with a $2,000 max over the 2-week period. The EFMLA provides an additional 10 weeks of paid leave, and it's payable at that same 2/3 rate of pay, up to $200 per day, and up to $12,000 in aggregate. If sick leave was already used, but the EFMLA was not, the employee can get 12 weeks off, but only 10 of those weeks are paid. Employee can use any accrued paid leave to offset the unpaid EFMLA if they so choose. Let's look at the paid sick leave, the EPSL. This is independent and separate of any time taken under the FMLA. It doesn't count towards any other paid sick leave provided under other state or local laws. And it's important to note that this can only be used once. This is regardless if it was used by the employee prior for a different reason. So for example, if you have an employee that used it in May after testing positive and staying home on doctor's orders, they can't now use it for schools being closed. Once it is used, it's gone, even if it was used in the past for a different reason. Another important point is that it can be used intermittently, but again, the employer has to agree to it. Employers should consider if this is feasible for their business. And remember, the EEOC has recommended that employers are flexible, be flexible on the leave related to COVID-19. And currently, I don't see it changing anytime soon, but currently it's effective through the end of the year. The FCRA paid family and medical leave, the EFMLA, unlike the sick leave, it's tied to the FMLA. If an employee used FMLA, then it counts toward their EFMLA, and you essentially just get 12 weeks total for both of these laws. If they use their 12 weeks already, either as regular FMLA or as EFMLA, then it is gone. It's same as a sick leave. It can be used intermittently with employer agreement. And again, employers should consider if this is feasible for their business and be flexible when they can. And I understand that you can't always allow intermittent leave. Let's look at some of the practical applications for FCRA related to the school reopening plan. These are some of the questions that I've been getting already from some employers as these plans start to trickle in. So let's look at this first one. Can an employee take FCRA leave if their child's school is open, but the employee opts out of in-person learning and selects remote learning instead? This assumes that the school is open 5 days a week for all students. The short answer is no, because the school is open. If you look at the however bullet point, if the school is operating at a reduced capacity, then it may be considered closed under FCRA. I put that in there because that is from the Department of Labor guidelines for the summer camp that they issued sometime in, I believe it was late June. So if the school is working at a reduced capacity, there is a possibility that FCRA would apply. And the next bullet point there is saying that the sick leave may be available to care for a child who has been advised to stay home or otherwise quarantine because they are particularly vulnerable to COVID-19. I put that in there just to remind employers that there still are other reasons under FCRA, and not just the childcare being closed, where an employee could trigger the protections of the Act and paid leave. But that point does not go to schools being closed. And again, as I am hammering home, we do need further guidance from the Department of Labor on this issue, because we just don't have anything right now. The last bullet point here, just as a reminder, if the school is going only all remote, and there are still some that are doing that, then FCRA will apply if the employee meets the criteria of being the primary caregiver of their child. Okay, here's another question. This one is actually dealing with the hybrid model. Is an employee eligible for FCRA leave if the school operates under a hybrid system, or in-person learning is restricted to certain days of the week, for example, Monday to Tuesday, and is supplemented with remote learning, for example, Wednesday to Friday? As I said before, this seems to be, at least currently, the more common plan that schools are choosing, even allowing the parents to choose either this or a total online learning option. I'm seeing it becoming more standard across the country as more districts tend to adopt it, especially the 2 days in, 3 days out plan. And you see the answer there I have is it depends. Unfortunately, we still just don't have clear answers on this. But looking at the current Department of Labor interpretations, their FAQs, it does seem that for those 3 days that the student is home, because essentially that school is closed to them, FCRA would apply, and a parent could get FCRA leave for those 3 days a week. This would also apply if, for example, the school had to temporarily close and go all remote because of a positive case of COVID-19. Something I don't have on the slide, but it's related, and I have gotten this question as well. If the district is operating under the hybrid model and gives parents a choice between the hybrid and all online, which a lot of them seem to be doing, what happens if the parent chooses all online, all remote learning? Would they then be eligible for FCRA leave? And unfortunately, the answer to that is I don't know. It's unclear. I'm hoping that the DOL will give us some more guidance on this. As I sit here now, I would argue it probably would apply because technically the school would be considered closed for those 3 days a week to all students. But again, I don't have a crystal ball. I don't have the answer on that at this point because we do need more Department of Labor guidance. And there just aren't enough clear answers at this point, mostly related to FCRA. I do expect it to come down soon, and hopefully that'll give more guidance to employers on how to handle what's gonna, I hesitate to call an avalanche, but I think what's going to be a lot of requests for time off for your employees who are parents dealing with these child care and school reopening plans. Okay, on that note, I'm going to hand it over to Allison. Thanks.
All right, thanks, Jen. My name is Allison Hughes. I'm a partner in Smith Amundsen's Labor and Employment Group. And the next thing we're going to talk about is other leave considerations. So John went into the FCRA considerations that employers with 500 or less employees need to consider, but there's also other laws out there that might apply when employees cannot come into work because schools are closed and they don't have childcare for their children or they need to assist with e-learning. State and local governments have been enacting new laws specifically addressing this COVID-19 situation. For example, in April of 2020, California enacted a new law that required COVID-related supplemental pay to food sector employees that wouldn't be covered under FCRA. Other examples, New York City and LA have both enacted new laws related to COVID-19 for employers with more than 500 employees where they cannot come in due to lack of childcare or school closures. Not only are state and local governments enacting new laws to address COVID-19, but also existing paid sick laws are now being interpreted to specifically apply to COVID-19 situations. So an example that's probably relevant to a lot of people on the call is the Chicago paid sick leave law. As background, you qualify for that for any employee that works 80 hours in any 120-day period in Chicago, and you earn 1 hour of sick leave for every 40 hours worked, up to 40 hours in a 12-month period. Now, the law, when it first came out and everybody was reading it and seeing how it would apply to them and how they could apply it to their workplace, probably ignored language in the law that said you can use paid sick leave if the child's school is closed due to a public health emergency. Years back, we probably just glossed over that, thinking, what would that mean? That's not relevant. Well, we're in the middle of a pandemic, and now it applies. So Chicago paid sick leave law is certainly going to apply here if a working parent says that their school is closed due to the pandemic. And you need to make sure that you're providing them the sick leave if they still have some available. It's also important to know when you look at the Chicago FAQ page on application of the paid sick leave law to COVID-19, that not only can an employee use this if their own child is not in school due to a school closure, but also if they're the caregiver for somebody else's child. So the specific example that the FAQ resource stated was if somebody said, my sister's son's school is closed and I need to assist with that, if they're going to be the caregiver, you need to let them use that leave. So just make sure that not only are you considering FCRA leaves of absences and leaves that need to be provided, but also leaves under other paid sick leave laws. And as the slide shows, there's just a ton of different ones. So contact a lawyer if you need to flesh it out more and make sure that you're monitoring any new laws that are enacted in the absence of Congress enacting additional leave coverage. So moving on to the next slide. John had mentioned the issue of COVID-19 exposure at school, and he had said it's not a question of if, but when. And that's relevant for employers for two reasons. There's two big implications. One is what John talked about, that when there's an exposure at school, whether it's in the classroom or an outbreak at the school, most school districts are probably going to require some sort of quarantine, whether it's if you're in the classroom, all those students need to stay home for 14 days, whether the entire school needs to stay home for 14 days. We're waiting to see how that all works, and there will likely be differences in school districts how that is applied. That's relevant for employers because even for working employees that are sending their kids to school 5 days a week and can continue working as they had before, they don't have these childcare road bumps, they're going to have it anytime there's these quarantines. So not only do you need to be worried about your employees whose children have a hybrid model or who are remote learning, but even for those employees that you think we're fine, their kids are in school 5 days a week, there's still going to be interruptions where they're applying for leave because their children need to stay home and quarantine. So something for employers to be aware of when they're trying to figure out the crazy patchwork of scheduling that's going to be going on in the wake of this. The other implication for employers is the question of whether or not, if the child needs to quarantine, can the employee come into work? Let's say this is a scenario where the employee's partner is home with the child, so there's no child care issues, but it still raises the question of if there was an exposure at the child's school, do you want that employee then coming into the workplace and potentially posing a safety risk for your employees? There's no clear answer for this. It's up to the employer's discretion. So I'm going to give you a couple considerations to use to try and make the best decision for your own workplace. The first is the question, was it the employee's own child that tested positive? If that's the case, of course, you should have that parent quarantine as well, because there's no way that parent isn't within 6 feet of their child while they're sick, and that would just pose a big risk to the workplace. You would have them quarantine. The trickier question is if there's no indication that the employee's child has COVID-19, just out of an abundance of caution, the school district is having that child quarantine. It's a trickier question whether or not the employer should then let the parent come into the workplace. First question is, how feasible is it for that employee to work from home? If the employee can be just as productive and accomplish just as much, it would lean towards having that employee quarantine just out of an abundance of caution to keep your workplace as safe as possible. It becomes a far trickier question when that employee cannot perform their job from working from home. And of course, that's the situation and the reality for lots of different positions, for lots of different employees. So the best I can do to guide you employers on what to do is give you some considerations. The first is, how common are these quarantines going to be? We just don't know how many surges of COVID-19 there are going to be in schools and how common these quarantines could be, because that could speak to the real interruption of the workplace if you also have the parent quarantine. the research is mixed on whether or not kids are big transmitters of this virus. The fact that kids are often asymptomatic or have very mild symptoms make it very hard to track whether or not kids and children are the ones that are spreading the virus. I'm not a doctor or an epidemiologist, but I have looked into this enough to try and give you a clear answer, and I just can't, because there's research on one hand that say children are not transmitters. They cite to schools opening in Denmark and Belgium, and the fact that children are getting less sick and they're smaller, so their sneezes and coughs emit less particles, and that would lend to the fact that they're less likely to be infecting others, and therefore the risk of exposures at school is a little bit less to then get brought into the workplace. On the other hand, researchers are not willing to say that kids are not transmitters of the virus. They cite to school outbreaks in Israel, as well as an outbreak that occurred in Missouri at a teen sleepaway camp, and just the fact that we know that other forms of coronaviruses can be spread through kids. So any parents on the phone call right now know that when your kid first went to daycare or first went to school, they caught the common cold, which is a type of coronavirus, and then spread it through the family most likely. So we know, at least for some coronaviruses, kids are getting it and passing it on to others. One other consideration then, when you're thinking about the safety of your workplace and keeping your workplaces free of COVID-19 as possible, is looking to the travel bans that have been enacted throughout the country, most, I guess, relevantly in Chicago. So as of right now, there's a requirement that people quarantine for 14 days if they travel to 18 states. As of July 31st, it will be if they travel to 22 states, now including Wisconsin, most locally. The way that Chicago is deciding what states fall within this travel ban or this need to quarantine is if that state is a hot spot, meaning that there's at least 15 infections per 100,000 people. Under that logic, and if you know, governments are thinking that's high risk, if there's one infection at a child's school of 500 kids or 1,000 kids, it would possibly warrant a quarantine if you are able to, you know, have that flexibility in your workforce and have that employee either work from home or take a leave to be quarantined. It would be the most cautious. So moving on to the next issue or the next slide, we wanted to talk about school employers, if they're the school employers on the phone call, what to do when teachers and staff are calling in and asking for accommodations or asking to not have to come into work. This is relevant for school employers who are certainly being inundated with these requests, and it's also just a good revisit of the issue for all employers on the call who, when their workplaces open back up, certainly were given requests for these accommodations, and they're probably continuing to roll in. So we just wanted to go through what employers should do in these situations because, you know, COVID-19 is unprecedented and it's a bit of a different world, and it's important to make sure that employers are being as cautious as possible because I do believe there's going to be a flood of litigation after this for failure to accommodate related to COVID-19 risk. So as with any request for accommodation, the employer is going to handle this the same as it would, as it always had pre-pandemic world, engage in the interactive process. The most important thing to remember is employees do not need to use buzzwords. They don't have to say disability. They don't have to say requesting an accommodation. If an employee says they don't want to come into work or can't come into work due to COVID-19, my recommendation, especially with how much litigation may follow in this, is always vet it to see if it needs to go through the interactive process. Why is the employee not comfortable coming in, and wait to hear if it's a buzzword, some sort of medical condition or disability. So what would be a protected reason that an employee asks not to come into work due to COVID-19? If the employee simply says they're afraid to come in, they're worried about coming in, those are not disabilities protected under the ADA, and so you may not need to engage in the interactive process. However, if the employee uses stronger language implicating a mental health issue, such as anxiety or depression, in those situations, employers should consider engaging in the interactive process. So if an employer says, I have panic attacks and anxiety about coming in, ask for medical documentation and go down the road you normally would under the ADA. Additionally, if an employee says that they're high risk, you need to go through the interactive process because the EEOC has explicitly stated that if an employee has a disability that puts them at high risk for COVID-19, they are protected under the ADA, and you have to go through the interactive process to see if they could be accommodated without undue hardship. So What are the disabilities that make somebody high risk for COVID-19? Chronic kidney disease with dialysis, chronic lung disease, diabetes, liver disease, moderate to severe asthma, severe obesity, and I would add pregnancy to that list. Once an employee has brought up something that would trigger the need to engage in the interactive process, the next question is what accommodations can be considered. There was a host of case law that we would always use pre-pandemic, saying that employers are not obligated as a general rule to allow employees to work from home. If a condition of the job is to come into work, it's not reasonable to ask not to need to come into work. All of that case law that employment lawyers hold so dearly is out the window right now in this pandemic world. The EEOC has specifically stated that employers need to consider telework as an accommodation. It's not always possible, and depending on the job, it's quite easy to say that wouldn't be reasonable, it wouldn't be possible, it would be an undue hardship. But if the employee can, be productive and do the same type of work that they do in an office, you need to consider letting them work from home. There's an important consideration for any time an employee is going to allow an employee to work from home. Any reasonable accommodations that that employee had been afforded in the workplace, even separate from COVID-19 or any high-risk issues, needs to also be extended to that employee at their home work setup if feasible and would not create an undue hardship. So, for example, if you have an employee who has macular degeneration and 3 years ago requested a bigger computer screen because they were having vision problems, went through the interactive process, no problem, you installed a bigger screen in their office so they could see better, and now that same employee years later is working from home due to COVID-19, the employer, as long as it's not an undue hardship, now needs to provide a bigger screen at their home work setup. So something to keep in mind that those reasonable accommodations can travel home to a telework setup. Now, not every employee is going to be able to work from home, as I discussed, so there's other accommodations that also need to be vetted and gone through. Make sure you're documenting all of this in case there's litigation that comes up later. The next one is the question of leave. If they're not covered under FCRA or the paid sick leave law, there is a possibility that they may need to be provided leave under the ADA as part of the reasonable accommodation process. However, the leave cannot be indefinite. That's not a reasonable accommodation. Severson case in the Seventh Circuit has confirmed that, and that's still good law. Under the ADA, it's not a leave statute, and you don't need to just indefinitely let somebody take a leave because they can't come in due to COVID-19. If work from home or leave are not options for that employee, the employer should get creative and try and figure out if there is anything that the employer could do that would ameliorate the risk of COVID-19 for these employees or lessen the anxiety or depression or panic attacks that they're feeling. Can you move their workspace to a more isolated area where they're not in contact with anybody? Can you switch their work hours and have them come in at a time other people aren't in and they can still accomplish the same thing? What can you do to reduce the risk of virus transmission that would make the employee feel comfortable coming in? If you can afford it, this is a time for flexibility and creativity. Do your best to try and think of it. A couple special considerations under the ADA for the COVID-19 world is one, there's going to need to be more flexibility than even before from employees and employers. Employers are going to be inundated with requests, most likely. Be as diligent as possible and front the issue. Let employees know if there's going to be a delay in getting back to them and just say, we're being as diligent as possible. We'll get back to you soon. We have just so many requests. We're doing our very best, but we're not leaving you hanging. And the same thing will be true for employees getting medical documentation. Healthcare providers are bogged down with crazy serious issues right now, so they may have a delay in getting medical documentation over to the employer. If it's reasonable and you can grant an extension of time, do it. The last thing is that employers are generally not allowed to ask employees about their disabilities, but the EEOC has explicitly provided that this pandemic constitutes a direct threat under the statute, and that's an exception to the general rule. So employers can ask employees if they have high-risk conditions if they're required to work in close proximity to others. So just something to think about. All right, moving on to the next slide. So we've talked about all these different issues. Let's talk about some options for employers that they have to do their very best in just an absolutely difficult situation. Like with prior COVID-19 issues, school reopenings are just going to cause a massive headache for employers. As John mentioned, in the spring, When the schools and daycares all closed across the board, it was a nightmare for employers, but the one benefit was at least all working parents were in the same boat, and employers didn't need to handle this patchwork of different situations. Now we have some parents who can go to work 3 days a week, some parents who can work in the mornings but not the afternoons, some parents who their child is doing e-learning 5 days a week. It's just different for every single working parent. They're all in different boats, and that makes it that much more difficult for employers to handle. When you're handling it, the bottom line is you need to balance your need to effectively operate your business, and that is a legitimate concern and needs to be addressed, against the need for compassion and understanding in these crazy times and the need to protect your workforce, employees, and their families. So what can you do? Lots of working parents are going to be asking to work from home, take leaves of absences. First, you need to abide by the existing policies, follow FCRA, follow all paid sick leave laws, and then you can also think about going beyond what the law requires if it's possible for you to do it. The benefit, as John mentioned, was you can maintain your workforce, increase employer morale during a very, very difficult time for everybody. And some of this flexibility will help you with your staffing, with trying to make sure that you can meet your objectives as a business with employees needing to be in and out on leave. John mentioned that there's a risk of losing talent and that you want to make sure you're retaining your workforce. And preparing for this presentation, I saw a study that 1 in 5 working parents is considering leaving the workforce right now, them or their partner. And the concern is greater for working women, and the concern is even greater for working women of color. So all diversity initiatives that you've done to diversify your workforce, to include more women in roles, and also just to generally have talent in your company, now is the time to do your best to maintain that talent so that when this pandemic passes, you have a good workforce still in place. So you can allow flex schedules or alternate start or end times if that helps. Maybe a parent has a situation where the child is going into school only in the morning. Can you somehow change their work shift where they can be working when their child is in school or for the majority of that time? Can also allow employees to draw from their PTO banks and make the policy more flexible if that's possible for you. Maybe previously there was a restriction on using a certain number of PTO days all in a row. Can you retract that policy just temporarily during COVID-19? Can you let employees borrow against their time that they're going to earn towards the end of the year? Anything you can do to show some flexibility and goodwill, even if it's the difference of just a few days, is going to go miles to all of these anxious working parents that just don't know how to figure it out. I'd also recommend cross-training employees in different positions so you have even more flexibility in scheduling and shifts. When certain employees can't come in, can you draw from different positions that then could come in and cover those positions? And then finally, allow employees to work from home whenever possible. Beyond just allowing them to work from home, you can be even more flexible if it works for your operation. Can employees request to schedule conference calls during certain times when their children are at school, if there's only certain days that they're at school? Can you accommodate them if they say, my child is napping at this time, this would be the greatest time to do something that requires focus and conference calls? If it's possible to accommodate that, it's a good idea too. This is the time to work together and be understanding and understand that the situation is difficult and undesirable for both the employers and the employees. The final 2 things I would recommend is that each request to determine if they're covered under the ADA and make sure that everything is being consistently done. We'll talk about litigation pitfalls in a little bit. Train all managers on all the considerations and all of the areas of flexibility and accommodation you're going to extend to employees. Make sure that this is done from the top down, so all managers are allowed what you're going to allow and what you're not going to allow. And that will make sure that there's consistent application across the board, which will be very helpful in eliminating litigation risks, or at least reducing them. So we're going to move on to the next slide. The next thing that we wanted to cover is the new normal of childcare and the fact that it's going to require flexibility from employers and employees. Employers are going to need to make tough calls, and they can't accommodate every request of a working parent, beyond what is covered by the law in many instances, because the fact of the matter is employers are also hurting right now and need to make sure that they're operating effectively. So this is a tough reality, and what can you do for your workforce when you're going to be making these tough calls? showing support for and acknowledgement of the difficult position of working parents will go a long way for workplace culture and morale. Remember that you want to preserve your workforce and its morale because this eventually, someday, over the rainbow will pass, a vaccine will be here, and things can go back to normal, and you don't want to have to start building your workforce up from the ground up. So what are some things you can do beyond what we've already talked about? We talked about flexibility, easing restrictions on PTO, allowing work from home, allowing alternative work schedules, anything you can do in that way. Also, John mentioned be proactive and start the conversation. It really makes employees feel like they're cared about when an employer is reaching out and saying, what is your situation? Do you have any, issues with schools reopening? I want to check in. And this is beneficial for the employer too, so they can collect the information and jump on this problem instead of having requests roll in, and then you just don't know the extent of the problem and the patchwork that you have. Also, for those employers that offer employee assistance programs, this is a great time to just send out a quick email and remind all your employees that you offer this service, often free of charge. This is a way to address and recognize the increased stress and anxiety of this pandemic, particularly on working parents. And a last consideration is you can consider providing a childcare stipend or additional PTO if possible. John mentioned even a small amount can go a long way in just making the employee feel like the employer is acknowledging how difficult this is. So now let's talk about potential discrimination pitfalls. This is going to be a key issue, and this is why it's so important for managers to be trained and to make sure that everything is consistently enforced, because we're already seeing some discrimination lawsuits coming up, and I think that they're going to continue in this COVID-19 world. So the real risk of discrimination lawsuits, an example that just came up is a woman sued her employer in San Diego for gender discrimination. She claimed that she was working from home during the pandemic, meeting her productivity deadlines and things like that, but she had children yelling in the background of phone calls and was disciplined for that, and also received resistance from her managers on scheduling phone calls during naps. She brought the case, and it's, went viral. Everybody knows about it. And generally, it would be completely appropriate for an employer to require an employee to have childcare when they're working, and it's still appropriate to always require the employee to be meeting productivity deadlines, to be present during all meetings. Those things you can enforce and you should enforce, but just be careful how you're doing it. Always have it tied to the quality of the work, the productivity of the work, concrete things that can be enforced. It's not a good time to be telling an employee that they can't have a child in the background, because the fact of the matter is, with schools closing, that's just going to be a reality for right now with this pandemic. I also bring this up because not only is there a risk of discrimination lawsuits, but there can also be a risk of PR nightmares for employers. People are very stressed out and upset right now, and things can go viral very quickly because everybody is just at home online, and generally things can just go viral in the world in 2020. So an example of that is Florida State University faced a tremendous amount of backlash when they issued a rule that come August they would not allow employees to work from home while also taking care of their kids. This went viral. It was covered in multiple national magazines, and the university ultimately had to withdraw that and say that they would allow employees to work alternative schedules or take leave if childcare wasn't available. So again, it's kind of new rules. Before, a rule like that would just be pretty standard, but we're in the middle of a global health emergency, and you just want to be careful how you frame stuff. I'm not saying that you can't require employees to still do good quality work, meet their productivity deadlines, but there has to be some flexibility in the face of this pandemic. So what kind of discrimination claims can employers face? Several state and local laws explicitly prohibit employers from discriminating based on parental statuses. For example, the Alaska Human Rights Law includes parenthood as a protected status. The DC Human Rights Law prohibits discrimination against a family responsibility, and the New York Human Rights Law includes familial status as a protected category. Relevant for a lot of people on this call, the Chicago Human Rights Ordinance was recently amended to prohibit discrimination based on parental or caregiver statuses. And these are all recent, in the last few years, amendments to these local laws. So I think that these are going to continue to pop up in human rights laws across the country. There's a new recognition that caregivers and parents are going to be afforded a protected trait category under these anti-discrimination laws. Title VII does not explicitly protect parents or caregivers. You can't bring a Title VII claim saying you're fired because you're a parent, but plaintiffs have, dating back decades, brought discrimination claims based on sex discrimination, where they claim stereotypes or biases about parenthood led to an adverse employment action. And we see that most often with working mothers. They claim that there's some view that working mothers can't be as devoted to their job or are not doing as good of a job because they have children. So be very aware of this as you're navigating all of your employees that are parents having issues with childcare and school closures. What do you do about this? Just always make sure that any discipline that you need to issue to employees who are not performing is concretely linked to the quality of their work, the amount of their work, or their productivity. Use concrete examples and don't reference childcare issues. And again, be as flexible as you can, knowing that the reality of this pandemic is some parents are going to be home with kids or have childcare issues, but if they can still perform their work, be flexible. If they're not doing a good job of performing their work, make sure that the discipline is linked to that and not the fact that they are caregivers or that they have children. And anytime you're doing that, you just want to make sure that you're not disciplining a mother for having children yelling in the background of a call, but there's a father in the next unit over that hasn't been disciplined for the same thing. So you just need to be on the lookout for these discrimination lawsuits that could be rising. Be as careful as possible in how you document stuff and train your managers about what you're allowing, what you're not allowing, and to always be using concrete parts of their work as the guidepost for any discipline that needs to be issued. All right, moving on to the key takeaways for employees. We've said this a million times and it can't be said enough because even everybody on this call is wearing their employer hat right now, but then also wears the employee hat, and it's just difficult for everybody across the board. Nobody knew that we'd be facing this pandemic a year ago, and it's just a time for flexibility, understanding, and also protecting your own workplace and making sure that you're operating as effectively as possible. So those are the two principles you're trying to balance. Make sure to plan ahead, be as proactive as possible, and if leave is needed, comply with FCRA and all other applicable laws. When you're affording these accommodations and leave laws, protect yourself by requiring documentation to keep all employees honest about their situations. Make sure that you've vetted that their school district actually is closed and they provide documentation of such, just to make sure that no employees are taking advantage of this situation. And finally, last slide, just in conclusion and food for thought. As we've mentioned a lot of times, this is a constantly evolving area. Everything is new, everything is still being figured out. So although there's no concrete guidance, I hope we've given you the laws as we know them and also considerations that employers can take when deciding next steps in dealing with these school closures. We've already said it's going to be case by case for each employer. Keep an eye out for new DOL guidance. And also keep your reference point on Smith Amundsen's COVID-19 webpage. We are doing our best to stay on top of everything and updating this resource webpage as frequently as new information comes out. Before we have time for a couple more questions, I wanted to also do a quick plug for my partners. Heather Bailey and Beverly Alfon are going to be doing a webinar on August 19th called Race, Religion, and Politics in the Workplace, also very timely right now. So be sure to look out for emails for that and to register for that. They give great presentations. So thank you so much for your time. And John, I don't know if you have any questions.
Yeah, we have a lot of questions. I'm going to try to hit some of them. There seem to be some that are FCRA related. One is we are not eligible for FCRA because of having over 500 employees. And our employees are healthcare workers. Do we have to provide employees any type of leave if their child is remote learning outside? For that, I would say, I think Allison covered that pretty well. If you're not covered by FCRA, no, you don't have to provide the leave. I have seen there's stories, there's articles out there on larger employers that are kind of mimicking the FCRA leave and providing it to their employees. And as Allison covered, a lot of the different flexible options and a lot of the things you can decide to work with to try to retain your employees and to show them that you're trying to work with them. Let's see what else we got. Sorry,
I'll jump in and answer
through here. Go ahead.
Okay. And John, feel free then to jump in after me if you'd like. But we have a couple questions about reasonable accommodations. One real quick, we will include the medical conditions that would trigger the interactive process that make you high risk under the ADA. The next question is age over 60 or 65 a covered disability in a COVID-19 world? It's a great question. Age does make you at higher risk for COVID-19, but the American Disabilities Act does not cover age. That's not a disability. So it wouldn't trigger the interactive process. And age is covered under the Age, Discrimination, and Employment Act, but there's no accommodation requirement under that act. So legally under those two statutes, you wouldn't have to engage in the interactive process under the ADA for age. However, because it is a risk factor for COVID-19, when we were talking about employers doing what they can and being the most cautious for their employers, you may want to consider allowing those employees to work from home if possible, or providing other accommodations to keep them as safe as possible.
Okay, let me now jump back. There seems to be a fair amount, at least earlier on in the presentation when I was talking about FCRA, and essentially the question seemed to be if remote learning is 1, 2, 3 days a week, does FCRA apply, as in is the school closed? Again, the DOL has not come out and said for sure that yes, it does apply because the school is closed, but if you put my feet to the fire right now, I would say that yes, FCRA would apply because the schools are technically closed to that student for that day or those days where they are only allowed to do remote learning. But again, the question comes up, well, what about the parent that chooses all remote learning when there is the option of like 2 days in and 3 days remote? And again, I just don't know. I would assume that it would be considered closed, but at this point, unfortunately, we just don't have clear guidance on that.
Okay, I'll jump in. There's a question. You mentioned that as long as the employee can work from home and be productive, then remote work would be a reasonable accommodation. If their production dips, is it inadvisable to go back on the accommodation and require them to come back into the office? Such a good question. I would advise that you only allow employees to work from home when you know that they can perform their job, of course. You don't want to set them up for failure and have them work from home, and also then you have the headache of trying to figure out what to do. When you provide the reasonable accommodation of working from home, I would include guideposts the best you can. So is there a way to quantitatively measure their productivity? You need to be able, I'm talking in general terms, complete 20 reports per week if you're working from home, whatever would be required working in the office. And then you have that as part of the accommodation. That's part of the deal. If they're not doing their work and not being productive while working from home as a reasonable accommodation, and you have that in as part of the offer of the reasonable accommodation, it's easier to then address it. If they're not doing their work while they're working from home, just because it's a reasonable accommodation does not tie the employer's hands. They can still discipline, they can still follow up and say, you need to be reaching your productivity benchmarks. If not, we're going to have to look into alternative accommodations, because it would be an undue hardship to an employer to accept an employee just not being productive while working from home.
Okay, I've got a couple more FCRA ones, which seem to be fairly popular. Is the EFMLA the first 2 weeks of leave paid at 100% or the 2/3 rate? If it's for school closures, it is paid at the 2/3 rate. And then another question, what if someone exhausted their FCRA time in the spring and now again have childcare schooling issues? Again, I think I mentioned this kind of briefly early on in the presentation, but if the employee has used their FCRA time earlier in the spring, it is gone. That if they've used up their 80 hours of the sick leave, if they've used up their 10, 12 weeks of the EFMLA, it's gone. As of right now, things could change. Congress could decide to do something different. But as of right now, it's gone, and it doesn't matter if they used it for a different reason, right? I think, as I said, if they used it because they were sick, then there's no problem with them not being able to use it again. And I think that's all our time right now. Again, thanks so much, everyone. We appreciate you joining us today. And if you see on that last slide there, that's our contact information if you have any follow-up questions. Allison, do you have anything else?
That's it. Thanks so much for joining us. And feel free, like John said, to contact with any questions.